Okay, good afternoon, everyone. Welcome to this panel discussion titled Can Tax Certainty Be Assured in Times of Tax Avoidance? Our moderator for this session is Dr. Suranjali Tandon. Dr. Tandon is an associate professor at NIPFP and a visiting senior fellow at the London School of Economics. Her research spans climate finance, sustainable transition, and tax law. And she's also a member of the European Association of Tax Law Professors and has been on the steering committee for the Global Tax Symposium since 2019. Our panelists are Professor Parthasarathi Shome, Honourable Justice Shri R.V. Easwar, and Shri Akhilesh Ranjan. Professor Shome is the founder chairman of International Tax Research and Analysis Foundation India. He has served as a member of the academic board for the Advanced Diploma for International Taxation, Chartered Institute of Taxation, London, and the International Tax and Investment Center in Washington, D.C. He has also served as director of NIPFP and ICRIAR in the past. Professor Shome is the recipient of the highest civilian honor of Brazil, the Commander of the Order of the Southern Cross in 2000 for contributions to the Brazilian tax reform. Professor Shome's research spans taxation, public finance, fiscal policy, and socio-economic governance. Justice Easwar is the former judge of the Delhi High Court, and he has served as the president of the Income Tax Appellate Tribunal, Ministry of Law and Justice. And he has practiced in the areas of revenue law, direct and indirect taxation, foreign exchange law, company law, and matrimonial law. And he has also served as the chairman of the 10-member committee to simplify the provisions of the Income Tax Act. Shri Akhilesh Ranjan is currently the Principal Chief Commissioner of Income Tax. He has served as the Principal Tax Commissioner of Income Tax, Principal Chief Commissioner of Income Tax, sorry, and he's an 1982 Indian Revenue Service officer and has also served as Director and Joint Secretary in the Tax Policy and Legislation Division of the Central Board of Direct Taxes, Ministry of Finance, Government of India. He has been included in the Global Tax 50 named by the International Tax Review in 2013 and 2015. And I now invite our moderator, Dr. Suranjali Tandon, to take over. Thank you.
Thank you, Malvika, for doing that unenviable job of leading the series of illustrious people. So I'm very happy to be here and with panelists, all of whom have been on several tax committees, and especially Dr. Shome, who was behind India's GAR. So why am I talking about this today? I think this topic is really close to my heart because ever since I began my work on taxes, all I've heard is that India's tax system is extremely onerous, very uncertain, and terms like tax terrorism were used quite frequently after the Canaan Vodafone case. In that context, what I've seen is that over the few years, there's been a shift, a paradigm shift in thinking about how do you address how MNEs plan their taxes, whether you call this avoidance, you call this evasion, or do you let it pass? And I think one of the pieces of legislation which has helped with this is the anti-avoidance measure, which is GAR. And the usual sort of criticism of it is that it causes more uncertainty because of its design. So the attempt today is to, if not convince, but at least leave the room with some thoughts on why we may be more welcoming of instruments like GAR. To provoke the room enough, because I think we just came back from lunch, is to talk about the most controversial case, which has caught attention amongst public, is the Tiger Global case. For those unfamiliar, this is also like a primer into how companies transact, how they structure, and why that creates the basis for designing an anti-avoidance rule. So here, just to give you like a broad overview, what the Tiger Global case was all about, there is an entity set up in the US called the Tiger Global LLC, which was formed and still has a partner called Charles Coleman. He holds an entity in Cayman Islands, a group of companies, and then further has holding company in Mauritius, which has sub-entities like Tiger Global International Holdings 2, 3, and 4. And Tiger Global LLC, which is at the top, is actually the investment manager for these three companies. Now, the interesting part is that there was interest to purchase the Flipkart shares, which again are of a company based in India, which is ultimately, you see the bottom box, which is Flipkart India, but these are not really held in India. They're held through an entity in Singapore called Flipkart in Singapore in that particular diagram. So these shares were held by Tiger Global. And what Tiger Global did is to sell off these shares to another entity. Now, if you can see, all of these are dispersed in different jurisdictions, right? So Tiger Global 2, 3, 4 are in Mauritius. Tiger Global, which is the holding entity, is in USA. And then you have the shares being held of the Indian entity in Singapore, and ultimately the shares and the value in India. Now, this transaction goes through, and what Tiger Global does is to reach out to the Indian authorities to say that, well, if I did undertake this transaction, is it possible that my tax residency certificate is sufficient? So now the question that arose is that the alternative process. So what's the usual process on how GAR is invoked in India? Just want to say this very quickly. I will look at the design, but the process is that you go in for assessment. The assessing officer looks at your furnishing of your information and says, well, it could probably trigger GAR, and goes to a senior official, which would be a CIT or a PCIT, I suppose. Correct me if I'm wrong. And then the official finds, well, this could trigger GAR, and they go back, they decide, and then this goes before a panel. In the process, the taxpayer can also go to the authority of advanced ruling to seek whether this is an impermissible avoidance arrangement. Now, in this case, what they did is to seek certainty from the authority of advanced ruling. There was no sort of triggering of the GAR prima facie. And what the authority of advanced ruling said that, well, it's prima facie an avoidance arrangement, and the taxpayer got out of the system, filed a writ petition before the court, and there these questions were asked and answered, and now Supreme Court has ruled in favor of the tax department. The question for the room is more that, how is this transaction structured, right? And if we say that the value actually is located in India, what was very interesting in this case as well is that the findings of communications on official papers also gave us a hint that a lot of the ownership in the management, which would be the way of determining the residence, was actually in Mauritius. Because the decisions were being made ultimately by the founding partner, even though you had these separate entities. So why is this being designed the way it is? And then do we need to deal with it through an anti-avoidance rule? Now, the GAR was not initiated in this process, and I think we have very seasoned officials in the room to be able to answer the nitty-gritties of it. But just to say that the GAR was not triggered, but it still raises the question of having these anti-avoidance practices being curbed through judicial precedents. And so, if you have that process, what does it mean for tax uncertainty for taxpayers? So let me begin at the very beginning, after having left the room with some thoughts on what avoidance practices look like, is why do we care, right? And I think there's been quite a bit of movement on that front. There's been a stress on tax certainty over the last decade or so. It started with the ADITS tax initiative, which was interestingly about capacity building and transparency, but it sort of got taken over by G20, and then Rood's team's been doing quite a bit of work on tax certainty. They celebrate Tax Certainty Day every year. There have been reports to emphasize on what can be done to make tax systems better. The OECD, in fact, carried out a survey with businesses to say that corporate tax and VAT are actually important for investment and location decisions. And I think that underscores why we need to look at tax certainty, because the presumption is that you would respond to tax changes which are very frequent by sort of not investing more in jurisdictions which are more uncertain. And earlier this year, Michael Devereux visited us. I think we had a short round table where everyone sort of was up in arms against his numbers, but I think this it creates enough ground for us to go back to the question on why uncertainty matters. India ranked the highest as per his survey. Of course, caveats apply. But that being said, even in general public discourse, I think there is quite a bit of framing on why there's a problem. So very eminent economists seem to allude to the fact that we cannot have a system that changes too frequently if we want to grow faster than we are. And then you have, small investor communities seeking more tax certainty, especially after the Tiger Global judgment that I just alluded to. So I've made my case of why we need to even look at this topic. I think the other important aspect for researchers is that then how do you define this amorphous subject, right? So what does tax certainty really mean? So again, IMF has done quite a bit of work. I think there's an agreement that tax certainty alludes to clarity in legislation. We would like better laws. I think India's also been working towards it. You want predictability and consistency in tax administration. So you don't want that the same particular aspect gets repeated over years, or the same aspect with two different entities gives you different outcomes. There's also been massive focus, even at the OECD, on the effective dispute prevention. What does that mean? That means that let's not be acrimonious and begin to contend matters. Why not we solve them before they go into dispute? And there have been quite a bit of innovations there. The team from Foreign Taxes Division is here, but probably they could talk about advanced pricing agreements and advanced rulings, as I had spoken of, as important instruments. And then you need a robust dispute resolution mechanism, which is basically to say that, okay, once you have found out that there's friction, how do you make it work faster and better? This is just a graph which looks very unreadable at the moment, but just to say that there are different aspects that are ranked here as per IMF's survey on what matter most to people in terms of uncertainty. And what we find is the bars for unpredictable or inconsistent treatment by the tax authority as being sort of consistently be a factor across the kind of income groups or regions in jurisdictions. And I think it's important to stress on this for my presentation, because this is exactly what worries taxpayers with respect to having anti-avoidance rules in place. Okay, this is the part before I go on to the design of anti-avoidance rules, just to reflect a little bit on whether uncertainty actually indeed affects investment decisions. I know that Ruth's done quite a bit of work on tax and investments, and I will preface this by saying that it's not rigorous empirical work, but it's just sort of a starter to say, at least to push back a little bit the narrative that, well, if you change things too frequently, or there were these significant developments in your legal system in terms of rulings, does that actually have a chilling effect, as investors love to call it? So I carried out two thought experiments here. One is, to look at, sorry, this is not labeled, but yeah, it has in the title. So one is the country risk premium. So Ashwath Damodaran compiles country risk premium assessment across jurisdictions. It's basically your risk-free sovereign rating plus any sort of volatility in your equity related to your debt returns, and that sort of gives you your risk premium. Now, what I did is that I charted out all of the major developments in the Kane Vodafone case and the introduction of GAR, right? And so if you see, even at the point where the income tax department had seized and begun to sell Kane's shares, the trend seems to be independent in a sense of these developments. So I don't think that there is a correlation or there's the so-called chilling effect in the numbers here. Of course, as I said, this is not rigorous. It could be tested through another empirical exercise, but this is just a thought I want to leave with the room so that we can provoke a good discussion. Then again, one is, of course, to say the risk outlook of the country did not look poorer. The other is to say, well, did it change investment patterns? So I'm just looking at net financial flows, which would, of course, take care of the fact that there would be repatriation of investments already made, and including new flows. And so what I see is that here too, the net investment seems to be on its own trajectory, not particularly impacted by these so-called significant effects in policy and legal frameworks. So those are my two sort of thought experiments with whether tax certainty does have the chilling effect. So if we are saying, okay, it doesn't, but we still want to manage the concerns around having an anti-avoidance rule, then how do we design this? Okay, so we're living in a world where we have practices where we're seeing companies design their businesses more strategically, more evidently around taxes. And if at all there's no impact on overall investments, how do we design an anti-avoidance rule which actually captures these transactions, right? So again, the IMF's done quite a bit of work on what an ideal design looks like, and I guess I'm going to pose that question to our panelists as well. I think there are multiple approaches that countries follow at the moment. They could have specific anti-avoidance rules. They've done this in the past. So they would say that, well, we just found out that these startups are just doing something to sell shares and make supernormal profits. So then you had something called the angel tax in India. And so that's something of the sort of a specific anti-avoidance rule. But transactions, as I showed you at the very beginning, can be so complicated, right? So you want to look at the information, you want to establish what the intent is. And so there you begin to see the importance of a general anti-avoidance rule. It's more principles based, right? So what are the principles of an anti-avoidance rule? It basically says we have to go back and see what the scheme is. Is there a scheme behind this entire transaction? Is there actually a tax benefit? Whether that tax benefit is actually distinct from a concession. So a lot of you in the room will say, well, the tax law was written a certain way. They were supposed to give an investment incentive to investors. So why are they now worried about them planning their business? But then you have to go back to see whether this is just merely using the concession, or is it antithetical to the spirit of the law? And so I think that burden is on the department to sort of look into the transaction. And most anti-avoidance rules have something called the sole or the dominant purpose, right? So it is okay, like in the mix when we invest, it is okay to think about taxes. But would the transaction look different if the tax rules look different? And I think that is the core of an anti-avoidance rule. And I think most taxpayers think of this as very broad-based and causing the problem, because it allows the tax department to open up a transaction to look into how it was designed. But just in terms of design, these are the principles of what an anti-avoidance looks like. For India, we have something which the GAR basically requires you to prove it's an impermissible avoidance arrangement. I won't go into much detail, but these are the kinds of arrangements that are listed. And for commercial substances, there are description of activities which would be seen as contradictory to having commercial substance in that in the location. Well, this is only in the domestic law. I don't know if there are many lawyers in the room, but all of this operates alongside your tax treaties, right? So the example that I gave to you was related to India-Mauritius tax treaty. And why was it a problem? Because just again, alluding to the interactions. So the the Income Tax Act and tax treaty allow the taxpayer to get a beneficial treatment as per whichever allows them, right? And so the tax treaty with Mauritius is particularly problematic because it allows capital gains to be taxed in the country of the residence. And in this case, the capital gains are exempt in Mauritius because this particular entity that I was referring to had a global business license, the GBL, which is exempt from capital gains. And so that creates a problem. So then you need an anti-avoidance measure, not just in your domestic law, but also in your treaties. And the two interact as well. So over the years, the OECD has taken massive strides in reforming tax treaty system. Yesterday, Dr. Shome was talking about the BEPS program. And one of, I think, the biggest achievements of BEPS program is the introduction of the principal purpose test in treaties, which basically is very generic as per the critics, but is an anti-avoidance rule, which allows you to curb some of these practices. So, so we're in a world where these exist in our law, and this exists in our treaties as well. So this is just to demonstrate what the language really looks like. And then you have 1944 treaties out of 3,000 tax treaties that apply a PPT. Okay, so I want to hit the nail on the head by saying whether it's a source of uncertainty or not. I remember reading Dr. Shome's report, which asked for the deferral of, the GAR, because essentially he wanted that this tax residency certificate issue be left out of the coverage, should not be sort of, GAR should not be invoked in those cases. And I think the Tiger Global case kind of brings back that discussion to life. Perhaps we can have a more lively conversation, but just to say that, tax certainty should also be looked at from the perspective of the tax administration. And so if these designs change, then perhaps, the design of your GAR has to be broad enough. It does bring sentiments of having increased uncertainty, but there are ways and means to address it, especially through the design of the process of appeal. Maybe I should. Okay, no, I think just to sort of conclude on this, to say that it's really a function of design and how broad you want to define avoidance, what procedures you put in place. I think the last slide will talk about practices across countries to say whether India actually sticks out as the sore thumb or not. Questions that have emerged from the case law, and I think underscore the need for an anti-avoidance rule to, in fact, manage the uncertainty coming in from, avoidance practices. What I think few considerations can help curb the uncertainty. One is that should the law defer to established procedures, allow flexibility in inferring avoidance through GAR? How far should it go in obtaining information? I think this is a concern that could be raised as enhancing uncertainty, because if you go back and think about the Tiger Global case, the information was actually taken through internal documentation. There's a recent GAR case of Hinduja, where there are communications which are internal to the company, which have been used to establish that the primary purpose was actually tax avoidance. And so how far the information can be procured. Again, think about that structure. There were so many jurisdictions involved, and that requires automatic exchange of information. So if there was any sort of breakdown of that system, would this information be available? Can we actually say this is tax avoidance? And can there be uncertainty that can arise from the appeals process, as we've seen in the Tiger Global case as well? So, so the GAR provides a framework. The question is that, do anti-avoidance rules actually keep investors from making more adventurous forms of transacting? So what I do here again is look at share of countries in FDI. And in 2017-18, we signed an amending protocol for the Mauritian Treaty, where the principal purpose test, I think, was eventually also introduced to the MLI. What you see is that the share of Mauritius actually dips and never picks up like it was before. Singapore stays it was a coterminous treaty, but it's quite interesting that Singapore stays up and significant in terms of investment, and US, which is known to use Mauritius as a location for passing on its investments, also sees an increase when Mauritius dips. So in my thoughts, I feel like maybe there is a potential for anti-avoidance measures to act as the deterrent. So your counterfactuals that, does it really work? There are some hints of it, maybe. And just to, underscore why we need an anti-avoidance rule, we've seen this, as I mentioned, you could have specific anti-avoidance rules, but what would that mean? Every time you see a transaction, you go back, change your law, which means that you make it more uncertain and it's only prospective. You can't act as on date. You cannot sit and interpret it differently that this is an avoidance transaction. If you leave it to the judiciary, as we have so far, there is also difficulty because they operate within the confines of how the law is designed. And so can you actually pierce through the corporate veil and say, well, this was an avoidance? I think there are limits to that. So if they're unavoidable, then can uncertainty be managed? I think just to conclude that there are a few metrics that I sort of looked at across GARs in different countries. So how you define avoidance. Do you have a panel process? Is there an interaction with the treaty? Do you resolve it better to say that, if you didn't invoke your PPT, your GAR would not be invoked, and similarly. And then, is there an appeal process? Can the taxpayer still get out of the system and ask questions? How your specific anti-avoidance rule and GARs interact, and disclosures around this. And what I see is that India's done quite a bit on this. It's very clear. Clarifications have been made repeatedly on how these different laws interact. Of course, there's an open-ended question on GAR and SAR, and there is also some ordering of PPT versus GAR, which, of course, we can discuss in our panel. And just to say that, points to consider is that India's not had as many disputes since the introduction of GAR. So 2017 was when it was introduced. I think we have four cases of GAR, and we haven't been iteratively changing our GAR, which has been observed in certain jurisdictions. I think it's worse if you go back and change your definition of avoidance. In terms of context, the UK had about 18 cases last year of GAR, and they had an 84% win rate for their revenue department. It gives a sort of a context to thinking about how we assess our GAR in terms of uncertainty. So I'm going to stop there, and thank you so much. I'm going to now turn over to my panelists. Justice Easwar, it's such an honor to have you with us. I did talk very briefly, and I don't know if I did justice to the interactions of judicial anti-avoidance rules and general anti-avoidance rules, but I would really like to hear your thoughts on whether a GAR actually broadens more the scope of, looking at arrangements and transactions. Does it add a discretionary element, as is often argued? And so how do you think that the JAR works in comparison to the GAR?
Before I answer the questions posed by you, I'm audible?
So you are.
I must apologize for not being present physically in Delhi. Some health issues. I was asked not to travel. Anyway, now that I'm there, we have a codified GAR in the Income Tax Act. So if there is a codification, then probably there is not much scope for discretion. Codification fosters consistency and certainty, and therefore the discretion element is, at least the attempt is to exclude the discretionary element. So whatever is there in the chapter 10A or whatever it is, that is what is to be applied by looking at a transaction. So I would be inclined to prima facie answer the question of discretion, that the discretion is excluded in the case of a codified GAR. Having said that, Now we have, it's my opinion, we have one of the finest GAR provisions, though 4-5 sections are actually, it's a pleasure to actually read how they have drafted these sections, and it does broaden the scope of certain expressions. For example, what is commercial substance? Something which is hotly contested issue. We have a separate section which deems and explains what commercial substance is, and there you may find that it really I would normally think as commercial substance is perhaps not the way in which they have looked at, and they have included much more. And unless they have probably raised the bar, and unless you satisfy all those conditions, then it will be difficult for a transaction to pass through that test. So I'm really not able to find fault with the GAR as it is drafted, and I wouldn't say it gives a lot of discretion. Ultimately, there will be interpretations, differing interpretations, as we have all seen. And coming to that, the contrast between GAR and JAR, that is judicial anti-avoidance. Between the two, I think I prefer GAR for two reasons. For two reasons, it has got a slight edge. In JAR, we are looking at rulings which come after 7, 8 years, 10 years. What is the whole purpose? The purpose is lost. And then, as recent experience has shown, there could be inconsistent rulings after a long period of time. For example, since Azadi Bachao was decided sometime in 2003, in 2026 you have Tiger Global taking a fresh look at what the circulars are. 25 years, 26 years have passed, and I think the circular was issued even earlier. So it kind of upsets the settled judicial position of what a circular is, what it is meant to serve, and all that. So these are the two major drawbacks in JAR, and JAR again could be subjective in the absence of a codified thing. Ultimately, when you come to practical terms in India, at least, matters go to judiciary, High Court and the Supreme Court only on the basis of the codified law. Therefore, even when judiciary has a lot of imagination as to what tax avoidance or abusive planning could be, evasion could be, still it is bound by the law. And then on the question of interpretation, there could be some differences. Having said all that, I think GAR has a slight edge over JAR. This is my take on that.
Thank you so much, Justice Easwar. I think that's quite reassuring to hear that you support the GAR being useful in comparison to the JAR. Mr. Akhilesh, I would want to turn to you. A lot of experience there in administration and policy and legislation. Taking from the points that Justice Easwar has made, do you think the judiciary's response has been as you would imagine to anti-avoidance? And are there certain things that may be required to course correct? What do you think would be the policy response to uncertainty other than GAR or with GAR?
Thank you, Suranjali, and thank you for that presentation and bringing on those points. But I think before we actually look at the Tiger Global ruling and the role of the judiciary, I think one should look at tax certainty in a broader perspective as to why is it an issue. You pointed out that it is an issue which has been commented upon by various people. India has the highest tax uncertainty, you said. Michael Devereux said that. But what is the source of that? And I think we have to look at it in a much broader context rather than just looking at GAR versus JAR or looking at judicial rulings as giving rise to uncertainty or the law being just ambiguous. Consider this, that it's a 15-year evolution, really, last 15 years as to how the law has evolved. We had this stress on domestic resource mobilization after the global meltdown, countries trying to raise more resources, realizing that a lot of revenue was being lost. Stringent measures to avoid, to counter avoidance of tax, which gave rise to new and more new practices of avoidance and evasion. We had things like the Panama Papers and the Paradise Papers, people making a whole industry out of trying to help tax avoidance. That tussle between the legislature, the governments, and the people who are helping tax avoidance, that tussle going on for a considerable period of time, that itself gives rise to uncertainty. The second thing is that the changing business models, the digitization of business models has completely upended the whole tax system. We have now, I mean, there is the vendor-customer relationship has given way to a vendor-customer-user platform, a multi-sided business model where the same relationships don't work. You have people who can render services sitting in remote locations. You have you can achieve a scale of business without having any presence at all in a particular jurisdiction. The tax system was not built for these things. The tax system that we have had in the last 100 years was not built to handle these matters. And therefore, when the governments try and somehow adapt the old tax system to try and meet these new challenges, there is more and more complication and more uncertainty. And then that's the second point. And the third is that the judiciary has been evolving in its view. I mean, Justice Easwar just pointed out how in the Tiger Global ruling, a 20-year-old ruling of Azadi Bachao by the same court has been held to be no longer relevant. They have not said that it was wrong. It was right at that time, but it is not right now. It does not hold now, which means that the law has evolved. The business way of doing business has evolved. The tax considerations have evolved. So it has to be viewed in a totally different light at the moment. So these three factors, I think, are the main underlying themes of this the whole issue of tax uncertainty. India, of course, has traditionally the nature of the economy being such that we have had a tax system for ages. We have had a lot of fair amount of aggression in the tax administration. So all those reasons may be there for a slightly higher level of uncertainty. But then it's a global phenomenon, the tax uncertainty. What does a GAR do then? How does Tiger Global fit into it? In my view, I think, as I said, Tiger Global is the culmination of evolution of judicial opinion. It is heartening, in fact, to me that the judiciary is able to see that the need to reinterpret laws in the light of current socio-economic realities. And I think that's a primary function of the Supreme Court. I'm not saying the tribunal or the assessing officer. They should follow the law as it is codified. But then the Supreme Court has the responsibility to look at what's happening in society, look at what's happening in the global economy, and then interpret those same laws in tune with this new reality. And so I find that whatever, I mean, they've said in that ruling is actually an appreciation of what's happening currently. This case of Tiger Global, just to go on 2 minutes, in fact, I was the principal chief commissioner then. To put the record straight, I retired as member CBDT in about 6 years ago. In 2016, when this Flipkart transaction happened, I was the principal chief commissioner international tax. And I got the letter issued to Walmart saying that you must withhold tax because we think that these transactions are taxable. The revenue thought that transactions were taxable. And we said, please come over, we'll help you compute your tax liability. So that was the first thing. So Flipkart, Tiger Global had come to me then, and I said that we will give you a finding, we'll give you a certificate for tax reduction at source within 7 days, but you have to give us the facts. And when they gave us the facts, our officers concluded that this entity in Singapore, the Tiger Global entity, was not really on the Flipkart entity was not really a Singapore entity. It was controlled entirely by somebody sitting in the United States. And those are matters of fact, so we'll not go into that, but that was the basis on which the authority for advanced ruling said that this is an avoidance scheme and we will not give a ruling on that. And the Supreme Court has essentially upheld that decision of the authority for advanced ruling, saying that yes, this is a case where tax avoidance seems apparent, and therefore there could be no ruling given by the authority for advanced ruling, and that's the significance of that judgment. So it's something which is it's a natural progression of judicial view, a progression in tax policy. GAR is actually, if you try and go back to precedents and try and see the legalistic view, in my view, GAR is not good law. In fact, it is not law at all. Taxation law tries to be clear in what is being taxed, when is it being taxed, how is it being taxed. A GAR is not clear on any of these things. The GAR is only saying that whatever you may be getting in your benefit may be getting, I can withhold that benefit if I find that you have abused the law. It's a very general statement. It is not law at all. It is a policy statement. It's a policy statement of the government saying that I have done my best. I have tried to put in a lot of anti-avoidance measures. I have done transfer pricing. I have done various provisions in the Act to address situations. But I am still unable to control the situation. Therefore, a policy statement comes up saying that I will have a general anti-avoidance rule. Now, the principles of that, very rightly, as you pointed out, the principles have to be that whatever be the language of the code, and I'm not going to that. Justice Easwar is happy, and with that code, and I'm happy that he's happy. So then the concept is essentially that there is a tax benefit. The whole GAR is triggered by a tax benefit. It is not triggered by a transaction. It is not triggered by the earning of income. It is triggered by the availing or a claim of a tax benefit. Hence, a GAR is inherently retroactive. It is applied in a year and the actual event has happened earlier. It is inherently retroactive out there. So, and then when you, regardless of the language of the thing, the basic thing that has been to be seen in the design of a GAR, is there a contrived and artificial arrangement? Is there an attempt to use or exploit existing language of the law in a manner that is not intended by the law? And I think that is a principle that is widely understood everywhere. The European courts have been very active on that. Any other court would point to that. That is the essence of that. So no matter what the language would be, I think courts will have to make that judgment of whether this is a contrived or artificial situation. Absolutely. And if you have that, then the question then is how do we, as you said, how do we make GAR more palatable? How could you ensure that it can still provide some amount of certainty? So then that, of course, we have the mechanisms, we have the approving panel and all. But then I don't see the need for any intervention by the legislature to trying to upset or overturn this ruling of the Supreme Court. I think it's a ruling which should be accepted as something which is appropriate in the evolving circumstances. We have to design mechanisms to now cope with this new brave world, and where things are so uncertain in a lot of dimensions. It's not just by one GAR, by just abolishing a GAR will not make things more certain for taxpayers in India. Let's look at it that way. So the attempt of the government must be to accept this GAR and then evolve mechanisms as to how we can provide more certainty to taxpayers. The taxpayers on their own part somehow have to also reconcile to this fact. Most of the problems of international tax disputes are created by lawyers. I'm sorry, no offense meant to any lawyers. But then it is the lawyers who would come up with these ingenious mechanisms of which necessitate a response, a policy response like GAR. So while the government is certainly responsible in trying to have a ham-handed approach of applying anti-avoidance measures, the industry is also, I think, can be advised to be less aggressive in their tax positions. I've heard, as you said, sir, that people are once again appealing against the Tiger Global judgment. They will never rest. They will keep on and they will apply pressure on the government and ultimately try and abolish GAR from the Indian statute. I think that's quite possible. So, but it is not the right approach, because that, as I said, it does not solve the problem of uncertainty. Removing one GAR does not solve the problem. You have to accept the problem, the issue, and cope with it by devising mechanisms. And I think that's where the emphasis should be now.
Thank you, sir. And I believe we have Mr. Goswami from the FTTR here. So I will let him speak after Dr. Shome about, all of the things that are spoken of. But Dr. Shome, going back to all the principles that you had thought about while framing of the GAR, I want to ask you, what are your thoughts on, the ideal design for GAR? I mean, I believe it's a world where we have to live with the new reality, as Mr. Ranjan is saying. So, and do these impact investments?
Suranjali, thank you. Now, that's a very almost undefinable question. Is there an ideal GAR? But before coming to, I'll try to answer it in a very amorphous manner, but I'm going to pick out, given the live issue of Tiger Global going on, three quotations, which is very self-serving, but it is just happenstance. I didn't even think that why there is uncertainty from GAR. And so I'm going to quote first the taxpayer's point of view, a little quotation, then the advanced ruling authorities' point of view that they have made it, and then the Supreme Court's judgment, like some words from the Supreme Court document that has come out, which has come to just my notice. So to begin with, on the taxpayers' plea, reliance was placed on the Shome Committee report, the Finance Minister's Budget Speech 2015, 2016 Protocol, CBDT circulars and FAQs to emphasize that GAR applies only prospectively to investments, which was, in other words, accepted by Tiger Global, made on or after 1st April 2017. Pre-2017 investments are fully grandfathered. Now, what did the Advanced Authority do? They reinterpreted it and said that this was not just an investment, it's an arrangement. And so what did they say? They said, as regards Shome Committee report and the CBDT circular dated 27/1/2017, the learned Additional Solicitor General representing government submitted that they are confined to the treatment of investments and do not extend to complex arrangements, lacking commercial substance. The Finance Minister's Budget Speech of 2012, which kind of imploded on the world, really, it was argued primarily addressed the retrospective amendments to Section 9(1) introduced in response to Vodafone. And that was it. The retrospectivity is what led to all the chaos. These amendments, later made prospective, had no bearing on the operation of GAR. The speech thus clarified that GAR would apply prospectively, that is in 2017, which implementation was ultimately deferred to 2017, 1st April. Accordingly, GAR became applicable from AY 2018-19, and the transaction in the present case pertaining to 1920 squarely falls within this ambit. So, and finally, what did there's such a huge, long Supreme Court judgment, but again here, the Supreme Court says the revenue distinguishes between mere investments, which are grandfathered for pre-2017 investments, and arrangements which are not grandfathered if the transfer occurred post-2017. it was contended that even if the investment was made prior to 2017, so that breaks the, actually, I don't know whether it's a law or subordinate law or what, the subsequent indirect transfer of shares post 2017 brings the transaction within GAR scrutiny. So in other words, the Supreme Court is agreeing here that because we are also agreeing with revenue that this was not just an investment but an arrangement, therefore we say that therefore probably post 2017 may apply. This is my interpretation of what the Supreme Court said. This position is fortified by the distinctions drawn in statutory rules, parliamentary committee reports, and the Shome committee recommendations between passive investment activity and active arrangement based structuring. Now, therefore, I believe that whether an investment is a part of an arrangement just because it is complex investment, or is it just one-time decision? But as you showed in this particular case, you see the kind of complex arrangements already. It's not one of the most complex arrangements. The complex arrangements, most complex ones are very easy to see just by the diagram, whereas this one is very clear. So to me, it would really seem to be an investment. I mean, it didn't seem to me from what you showed that it was a very complex arrangement. But I think revenue made the argument that it was an arrangement, and the intention of the committee could not have been that even pre-2017 an arrangement would be protected or grandfathered. So if an arrangement was, from the committee's point of view, was not necessarily to be grandfathered, but only investments, and this looks like an arrangement. Even though Tiger Global is arguing it is an investment, we think it's an arrangement, therefore it should be taxable. So what is the uncertainty? Uncertainty is it is difficult to argue that Tiger Global really thought it was an arrangement. I mean, I think International Tax Department high officials should know the intentions and all. But in my opinion, as I've talked to both sides at the same time doing committee work and later and so on, when I was in HMRC, where there was a special committee where the biggest representations were made, my own view is that it is very often a matter of interpretation and confusion. And that leads to the uncertainty, meaning complex multinationals are always working on the verge of uncertainty that can befall them. Whereas revenue is always under pressure from their superiors that are you really letting a kind of a tax avoider escape what they should pay? And that is where the conflict arises. But here I think I don't know whether I can agree fully with Akhilesh that GAR is not a law. You might call it that's why it is called GAR rule. You know, it is subordinate rule. It is not a law, and rules can always be changed, etc. So I agree that it's not a law, but that's perfunctory. I believe we need a structure because today, for certainty actually, because otherwise before GAR, what did we have? Other than JAR, as Justice Easwar was saying, and their opinions about JAR, we in the tax law had SAR, which is specific anti-avoidance rules. So there were identified sort of definitions where an avoidance could occur. So there were like, I don't remember now, either 9 or 19 different SAR rules. And all of that had to be consolidated so that the tax department didn't always have to go, does it fall here? Does it fall there? And people who worked in FTT, they would just tell me, this is an impossible area, you know, for us to, and then later we realized that, oh my God, we've missed this. And then, so I think we did need a law, but it's referred to as law, but it's a rule that would bring all of this under one umbrella. And that was done, my opinion, humble opinion, is that, and that's why I suppose the government formed a committee, that the first edition of GAR was the most nail-biting aspects from every country of GAR that had GAR. And so it was put together. I mean, so when I first read it, I said, this is no, not only interpretation, but the worst interpretation of what a taxpayer is. So the presumption that a taxpayer is just a potential tax evader. And my own experience, I can say, I feel we should always begin with the presumption that a taxpayer is not a tax evader, but a tax-related confused entity. Because never are tax laws clear. In India too, if you really look, who writes a tax law? Who goes to the tax law department is not necessarily a lawyer. Sometimes if, on, of is mixed up. And then it goes to the law department where the law is written by, again, non-law people. And then it comes back and we have some brilliant finance ministers. They look and interpret correctly or sometimes incorrectly, and you don't know how to correct them. So, the thing is, therefore, what we need is absolute clarity in such an egregious body of law and rules. But we cannot do away with the whole thing. Don't throw the baby out with the bathwater, as they say. So that's why we needed a fundamental churning and correction of GAR. And there I would agree humbly with Justice Easwar that the final GAR law that came out, or rules, really reflected a huge churning between the committee and the tax department. And I can also divulge today that the decision between non-protecting an arrangement and protecting only an investment came because of the relentless pursuit of the department, not because of the committee. Because the thing, if I chaired, I propelled the thing, I made the other members of the committee agree, and we had a joint secretary of extremely high caliber as a part of the GAR committee. And he always, of course, was protective of the department. And then I had to have lots of talks with him. And there were others, Mr. Rangachari, who was also CBDT chairman and insurance, also chairman one day. He's a chartered accountant by training. No one could be more brilliant than him. He was there, and there were one or two others. So the thing is that
and somebody from NIPFP, Dr. Ajay Shah.
Oh, Ajay Shah was there. So then the whole thing came out quite strongly, and the department gave us strong feedback, and there were many meetings where we met, and it came out in I think it came out in the best possible form. And that is why probably last year, if there were only 4 cases, because the retrospectivity is taking hold. The department cannot go back retrospectively all the time. And the law is very clear. So the department itself is seeing, I'm presuming this, that is seeing that, no, this is not a case. And no one is going to come on top of us and say, why didn't you follow this? And remember when Vodafone case came, the department actually told Vodafone, you have to do the withholding, and Vodafone refused. There's no such law. Why should you? And that was correct. That's why the law was changed and retrospective is allowed. But it went up to 62. So that was an absurdity in itself. So that's why the 2017 cutoff point came. And the current government is applying it correctly. So does GAR create a bit of uncertainty? I think yes, but it creates less uncertainty than the situation, what it would have been without a GAR, when we had the SAR regimes. Because at that time, investors really didn't know when the government would suddenly call them and say, there's something wrong in it. And there was nothing saying that not before 2017, not before anything. So it could be applied anytime, very, very randomly. So I think that GAR has this thing. So, and the other issue here is India an outlier? And here, I think really India is not the one outlier is South Africa. If you see their case, it's extremely rigid, the law. If I look at the United Kingdom, the law is again quite complex, but they apply it in the most egregious of cases. I don't want to say, but my feeling is that they are reticent about starting a GAR case any particular year. US has no GAR, as I remember. US goes, case by case and then says, yeah, we'll go after this. So that it's kind of clever enough. So from what you are saying and what you are saying, it's a kind of a US model. They say no need for GAR, etc. We will see if something, and we'll begin questioning. So I think, yes, uncertainty is caused. I think the counterfactual would have been worse. And because here, I think tax administration would be perforce taking up many more so-called GAR cases without a GAR context. And India is not an outlier. India has done quite well in terms of coming on. And it has nothing to do with the committee. It's got to do with the department who agreed with the law. That is.
Thank you so much, Dr. Shome. And now I will move over to Mr. Goswami. Thank you so much. He's the competent authority for India. And I think they've made a lot of points that you would love to respond to, including my presentation on Tiger Global. So over to you.
Thank you, Suranjali. In fact, I was amused, not amused, I mean, I noted that the title of this session is Can Tax Certainty Be Assured in Times of Tax Avoidance? I hope we are not in times of tax avoidance, because that is really bad news if that is actually the case. But that said, couple of things is there's two sets of issues over here. One is general and one is very specific to Tiger Global. Now, on the general issues as to do we need a GAR kind of rule? Can we do without it? I think it is incumbent upon any piece of law or any document that sets out any legal principle to ensure that it is not abused. A treaty ensures that it is not abused by having a principal purpose test. So similarly, any tax law, GAR resides in our domestic law. So therefore, it is necessary for any tax law to have within itself provisions that prevent its abuse. So it is in this context that we actually need something like a GAR. Now, is our GAR the best GAR possible? As Justice Easwar says that it is a good GAR, and I believe probably that is true. It can always improve. I mean, so much so that on the 31st of March, we have amended the rules of that were applied to GAR to bring an element of certainty, because it is you talked about certainty. Eventually, what is certainty? The certainty is a simple rule that the rules of the game should be known before the game begins. So I think while a rule is good, it can serve the purpose. There is always room for improvement, and the amendment that we made on 31st of March, we amended Rule 10U and Rule 128 is a step in that direction to give that sort of comfort that there are certain no-go areas, that it simply says that wherever GAR has not been invoked, we will not invoke GAR hereafter. I mean, in a retrospective manner. So generally speaking, we need a GAR. We have done what we can to make this GAR predictable. We have an approving panel which consists of senior officers. So we have done what we can to ensure that there is as a level playing field as it can be in a tax situation. Now, coming to the issue of Tiger Global. So I think one of the things Dr. Shome said very clearly, that facts should be very clear. We should see things as they are. Now, so much has been said about Tiger Global, whether it is an investment or whether it is an arrangement. One thing that we must always look at that Tiger Global was a very specific fact pattern case. It was a case that involved an offshore indirect transfer. It was not one of those cases which were covered by those grandfathering paragraphs of Article 13 of the India-Mauritius Treaty. This was something that was sitting in the residual paragraph of the capital gains article. We actually never had taxing rights in respect of offshore indirect transfers until we brought it in our domestic law. I think it was the year 2012 when we, and the only way that we could have activated that was by invoking agar. So this fact should always be seen. So whenever we read the Tiger Global judgment, we look at the obiter of the case, the comments that the honorable judges have made with regard to the cases, we must not lose sight of the fact that this is a case that has a very specific fact pattern. This is a case involving an offshore indirect transfer. The only way a Mauritian resident could have claimed the benefit of that paragraph was to show that he was a Mauritian resident, and therefore the taxation lay with the resident country. And the only way that he could have done that was by showing the TRC. And that is why the TRC has become such a key document in this case, and that is because of the facts of the case. So this is something that we should never lose sight of. Now, there have been so much discussion around this that Tiger Global has kind of set the clock back in terms of whether the TRC is sacrosanct or not. If anyone is confronted with a case like this, with the facts that are similar to Tiger Global, where the TRC will be the only document on which someone claiming a treaty benefit hinges, I think that much has to be allowed, that he will do some kind of due diligence as to whether this fulfills the requirements, I mean, the issue of substance or not. I am given to understand that there is within the Mauritian law the necessity of establishing that this is a matter of substance, that this is a transaction of substance before they issue a TRC. I am told that it has not been completely activated, but if you go to countries like Singapore, there is a specific section within the Singapore Income Tax Act that before they issue a TRC, they carry out their own exercise as to whether this is a transaction that involves substance. So I think this point or this reality that a TRC must come only after the issue of substance has been settled, or at least prima facie settled, is accepted all over the world. So if an Indian tax officer is trying to examine substance when he is shown a TRC as the basis for claiming a treaty benefit, I don't think he is wrong. Now, there can be questions as to whether we've gone too far on that, but I think the Supreme Court is with us. So nobody can fault us on that. It's one of the rare occasions where this time we come out on top. So I think, as I can understand that when a decision, yes, the point that Justice Easwar rightly made, that when after 23 years a decision comes, it kind of tends to unsettle things which we thought are settled. But maybe it is because these issues have never been examined. We've already established that there are only 4 GAR cases in India. That only means that these issues have not been examined in the context of GAR. The GAR has triggered into our law only on the 1st of April 2017. It takes some time. So just because this case has come after 23 years, as Ranjan sir rightly pointed out, what was actually established was that those facts are not relevant anymore, or that the way of looking at those facts is not relevant anymore. So as we begin to examine these cases, what we thought were settled positions will probably become unsettled in when a new law is interpreted. There was an interesting point in your presentation of this, the investment between Mauritius and Singapore, and it's always flung at us that post the 2016 amendment, the the investments from Mauritius have dipped, and as your graph said, never rose beyond a point. Actually speaking, the India-Singapore Treaty is far more strict as compared to the India-Mauritius Treaty. It has a PPT for many years. The India-Mauritius Treaty does not have a PPT even now. Now we are told that the Mauritian cabinet has got around to ratifying the treaty, the protocol. The India-Singapore treaty has a PPT for many years. The limitation of benefit clause applies to a larger set of transactions in the India-Singapore Treaty than it does in the Mauritian Treaty. So therefore, to say that it is because of the 2016 protocol that the investments have dipped may not be the entire, the full picture. So I think to make a quick point, I think number one, when we look at a case like Tiger Global, it is useful to have all our facts before us, what kind of transaction this was. The comments regarding TRC should be seen in that context. And positions getting unsettled is simply because this is probably now that we have begun to test GAR and its application to our cases. Maybe I'll stop here.
Thank you. Just asking, would that mean that we'll have more GAR cases in the future?
See, that is not for a guy sitting in FT&TR to answer. Maybe there was somebody from some principles is international tax, but why not? But why not? See, I mean, to make a quick point, one should not be afraid that the case will be taken to GAR. The important point is that we should be able to apply GAR correctly. I mean, even the taxpayer should not have an objection that there was a problem with the process. That is our responsibility.
By the way, can I make a quick clarification or addition, which is that in the same year, 2012, that the GAR report was written, almost contiguously, I was asked that please look into indirect transfers also. And I said, but why are they two connected? But then I read and so we wrote a separate one. And we found that there's no reason why indirect transfers should not be taxed, because even though both the owners are abroad, multinationals, but the assets are based in India. But we oppose retrospectivity of indirect transfers. So that is where actually the whole thing about retrospectivity, and because the world literally imploded against India at that point on that particular case. And so even and the then government in which I was working actually dilly-dallied, and then the elections came, and the GAR report was accepted, etc., etc., finalized. But the indirect transfer part was being churned, and the department and etc. It didn't happen. But because I think the current government, then in opposition, opposed very much in parliament this whole retrospectivity and called it tax terrorism and blah, 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 they were morally obliged to take some action. And that's how they eventually took an action, I feel. And in 2017, correctly, they said, we will not apply it retrospectively, but the law is still there. It is kind of there. But the current finance minister actually declared that we will not apply the law retrospectively. So that's how, and then suddenly again, Tiger Global has come up. And it's very funny that indirect transfer thing has become relevant, and the retrospectivity also, whether it is an arrangement which we can tax even prior to 2017 or an investment we cannot tax prior to 2017. And the Supreme Court ruled, no, it is an arrangement only, therefore you can tax. That's how it came up.
Thank you so much. I think I'm going to open it up for questions. So anyone has questions, raise your hand, and then probably at the end, I will go to Justice Easwar for his final comments. So questions? Shri?
Hi everyone. So firstly, thank you so much NIPFP for this gathering on this very critical issue given the current investment climate. I'm Shriya Kashyap. I represent US ISPF, which represents about 300 plus companies in the US-India corridor. So a very specific question on GAR. So following the CBDT notification number 54, issued on 31st March, which reaffirms protection from grandfather investments, does the government see any merit in issuing any further administrative guidance to ensure a uniform approach to GAR, particularly around field formations, and provide greater certainty to investors?
Thanks. There's a question at the back, and then Supreme. Harnik.
Hi. I have two questions. One on, Bhaskar sir's point that, Tiger Global is case specific, should not be generalized. But that observation of the Supreme Court in para 48, which is that, judicial anti-avoidance rule can still be applied in parallel to GAR. So, which means that if you are satisfying GAR, JAR can still be applied. So I don't think that is a specific statement. It seems to be a general statement. And then, to my understanding, GAR was brought in to have a codified law. And now, if JAR can still be applied, then what is the relevance of GAR? That is one. And second, to Akhilesh's point, that GAR is triggered by the main purpose, not a transaction. So basically, inherently, it is retroactive. So, sir, just an example. So, say it's a pre-2017 investment, and obviously there's a benefit in the treaty, say Mauritius. Now, the main purpose would be capital gains. Now, but in today, say I'm doing a dividend distribution. I'm not selling the I'm not selling the shares. So the main purpose, which is capital gains, is a perceived benefit which I may get in future when I sell it. So today, can I invoke GAR on the dividend transaction? I mean, like Rule 10U1D has a grandfathering for investment, that is very clear. So dividends are not grandfathered. But the point is that if the main purpose test is not satisfied of the capital gains, which is not there today, so whether can I invoke GAR?
Thanks, Supreme.
Thank you.
I'm asking something which is very general. Okay. And I will discuss this in my discussion on compliance risk management when I talk about it. Is that, Sir, Dr. Shome, I partially agree with you that at least the compliance risk management approach is segmentation of taxpayers, right? So you segment between high risk, low risk, medium risk taxpayers and so on. So my worry is twofold. One is that I now work in countries like Burundi and Republic of Congo. And I see this is a very erudite gathering. We have a large, tax administration. So this kind of behavior, which Dr. Shome pointed out, is they're always playing on this borderlines goes on, right? Among multinationals, that you're always playing on the borderlines. My question is it apparent to them that you're sticking out like a compliance risk sore thumb? Okay, is it apparent, or what is the behavior behind it? Is it that I take the risk? So I'm trying to understand in a behavioral sense. I will take the risk, and if I get within this tax, if it's a smart tax administration that catches me, I will say that, oh my God, there's no tax certainty. Okay, and then if all else fails, I will go to the government and say that, look, I'm going to, and this has come from a friend of mine, a colleague in the IMF, who happens to be in a small African republic, was the Commissioner General of Tax. That was the behavior that if you got caught, you went to the Prime Minister or the Finance Minister and said, oh, I run that alcohol company, I'm going to withdraw all my investments. For me, this is not so much of a legal problem, a drafting problem. It's a behavioral problem where you say, I will take the risk, I will go there and I will do something naughty. And if I get caught, then I will do, sorry to use the word lobbying, political blackmail, and say that I will get away with it. It's a problem for me because I see that the Indian system is very sophisticated and it has its checks, balances. In a less sophisticated system, it becomes even more difficult for A, the tax administration, and B, it sort of shortchanges the domestic taxpayer. So for me, this behavior I know needs to be countered. We know that the OECD had this gray lists and black lists and all that. But I mean, what were you thinking? You were passing, I mean, it's an immediate risk flag to me. If I'm looking at it, Cayman Islands, Mauritius, ding, 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 it rings bells in my mind. So what were you thinking? What's the behavior behind it? Is it this behavior? Because I see this pattern emerging time and again. And then you use the pink newspapers and cry foul, oh my God, there is no tax certainty. And this behavior goes on outside in a democracy like India, in certain non-democratic structures. It goes behind closed doors to the detriment of good governance in those countries. I just wanted to flag that.
Thank you, Supriyo. I think just being cautious about the time, I'm going to give everyone an opportunity to speak. Sorry, did you want to raise a question?
There was one there.
Oh, sorry, I missed you. Yeah, go ahead.
I am Saurabh Bhattacharya, Chartered Accountant. I have a specific observation on what Mr. Goswami said, that there is something in the Mauritius law which has not been operationalized, and therefore the TRC is something which has not been issued after going through all aspects of the law. Is this something which the government came to know in the Tiger Global case? And if not, why wasn't it made public so that it could have contributed to certainty and people would be aware that the TRC is to be looked at with some sort of pinch of salt and not sacrosanct?
Thank you. I think we have a lot of questions for you, sir. But before that, Dr. Shome has to leave. So I would give you the mic for any final comments or responses to the questions, and then we'll probably move to Justice Easwar.
Yeah. The thing is that I thank you for organizing this panel, and especially there are CBDT officers, ex-officers, several, and so it was very enjoyable. And of course, Justice Easwar, I learned a lot, but I also learned, and I'm glad I could convey Tiger Global's, the judgment. And as I skimmed through it, I realized that this confusion and different interpretations will continue. There is no way everyone is going to see, if Honourable Supreme Court is also interpreting it this way. As I said, humbly, that I see it as an investment. I don't see it as an arrangement. And so, in my humble opinion, but that's the way it came out. And given India's situation, I understand even if you lose in Supreme Court, you can again start the process. I hope Tiger Global will not, because no other country has this freedom as we have in India. That's why we have, ad infinitum. So I thoroughly enjoyed it, Suranjali, and Kavita. Thank you so much for inviting me. Okay, excuse me. I apologize.
Thank you so much. You were making a point and I stole you.
Yes, Suranjali. My name is Uma Maheshwari. I'm the views I express, the questions I ask are personal and may not necessarily reflect the government I work with. Excellent question. He made a very, very excellent question, and he did a lot of context setting for me to come in. I have this question for Suranjali. Why do we always have to tag operation of tax laws to uncertainty? That's what we do not understand. Domestic GAR and treaty PPT were put in place to fill a lacuna with Azadi Bachao pointed out. There is no law, so let's address. And as our ex-senior colleague stated, the tax department generally would be reticent to go for a general rule, but for the purpose of what Shome pointed out, for the purposes of administration, we have the general GAR and PPT. India is not an outlier. 136 countries have agreed to apply PPT as an MLI. The 2000 treaties that you said have an anti-avoidance rule. So there is international consensus. Why this hue and cry? Tiger Global, facts aside, as Goswami sir rightly pointed out, let's see it only outside the facts.
Tiger Global heralds in a new era of anti-abuse legality in this country. You know, a country is not expected to endure abuses. Simple, plain and clear. So India has always been a champion of tax transparency. Now the Supreme Court lends its support and weight to establish, to rein in the new anti-abuse measures. We are a real economy, right? And I just wanted to also add on to one more question also in terms of, I had the same doubt as Goswami said. I didn't read it the way it was presented, because that's not how we look at the question, because that's first point that I had pointed out. The second one is clubbing it with investment. You know, certain tax cases being brought in under broad investment treaties have been a menace, you know. So how erroneous we get when we try to see taxes from an investment perspective, because the worlds are different, the two worlds are completely different, and how much of a tax sphere, the taxation awareness has got into the public sphere. That's what something I want to leave with NIFP as well, that we simply cannot get into a hue and cry mode without understanding that it is a minimum standard that we have all agreed to.
Thanks. I'm just going to quickly respond to that to say that the whole presentation was to sort of support the argument that you cannot cry about uncertainty, because there is a general consensus and change. And even if you say that it impacts, if it were to be associated with investments, you don't see a very definitive impact prima facie. And so that needs to be explored, I think, and also spoken of more clearly. But going back to the questions that were raised in the room, I'm going to take 5 minutes extra perhaps, but maybe we can start with Justice Easwar. Yes, sir, do you have any responses to questions and comments made in the room? You're on mute.
Probably these, what I was saying, these are not probably questions specifically addressed to me, but nevertheless, I have one or two observations to make. This has nothing to do with the certainty issue or anything. It has everything to do with the way in which JAR is put in place, particularly the recent judgment of what we are speaking about. I said it had unsettled a position which was there for about 23, 25 years. And then the response was that there are fresh facts, things are different, circumstances have changed and all that. Now, one of the grievances which I have heard, because I was not directly involved in that matter, but post decision, one of the frequent grievances which has been aired is that if there has to be an unsettling, albeit for valid reasons, due to change circumstances or anything, judicially, before you apply JAAR, judicially there should have been a process which ought to have been followed, because both the earlier judgment of an Azadi Bachao and the present judgment which we are talking about are of equal strength. So perhaps that's why I said this has nothing to do directly with the subject which we are discussing, but it's about. So there is perhaps a slight jerk there. This could be one of the flaws in JAR. So you had asked me a question about which one would I prefer, GAR or JAR. So I said I would always prefer GAR. To add to the flaws of JAR is this recent example of a judgment from a bench of equal strength. So conventionally, traditionally, the judicial norms are that you assemble a larger bench so that more heads look into that. So that is one way of looking at it. One criticism which is leveled against that the court's observations against the circular 789 or whatever. Now, on the second aspect, now Dr. Shome also was pointing out this. Now, when investment and arrangement, when these are probably, the feeling is that it's mere play on the words. One is an investment. The court comes to a situation where that there is no way out. So suddenly you take the view. Oh, this is not an investment. This is some kind of an arrangement, and you cut the Gordian knot. So this is perhaps another feeling which I have come across. People have aired this also, which the criticism was that it lacked a substantial basis for the distinction made between investment and arrangement. The feeling was that they were probably loosely coined. These are the two observations which I want to make. Thank you.
Thank you so much. Thank you. Mr. Ranjan, would you make comments and then I'll leave it to Mr. Goswami.
I think there was a question out there which is directed. So yes, when I said that that GAR is triggered by a tax benefit. So let's imagine your situation when you're talking about dividends. You see a situation where there is a benefit being claimed under the treaty of a lower tax on dividends. I think that is the situation you're talking about. So now you try and see whether this is hit by GAR in any way. And then you have to go back to when was this arrangement set up. And then when you see that it is something which is set up, let's say in 2018, when dividends were taxed in the hands of companies and not in the hands of investors, I think the straightforward conclusion is that there is no tax benefit out here. Right. So, I mean, it depends. It tell you the facts that you're saying. I mean, you are noticing a particular benefit. Now you see whether that benefit is a contrived benefit. Is it an artificially arranged benefit? And you go back to what has happened earlier and you see whether the circumstances are supporting that view. So it will have to depend on the facts of the case. Just because something, I mean, one cannot say that capital gains was always the benefit that was envisaged. There are so many other benefits out there. Just to comment on this point on arrangement and thing, I think the government has been very, very fair when in this 31st March notification by saying very clearly, it is the income from transfer of investments made prior to 2017, which is protected. That's a very specific thing. So already a distinction has been made. All arrangements, GAR applies even to the earlier arrangements. It's one exemption that, okay, if there is an income from transfer of investments and the investment happened earlier, that is what has been. And I think that is patently fair. So I think the Supreme Court might have, said things which are creating this confusion. But the notification makes it very clear what the distinction that the government and the policy wanted to make. That this is what is protected. This is not what is protected. And I maintain that GAR, by its very nature, has to be retroactive. It will apply to past arrangements always, unless you specifically carve out an exception as a policy instrument. It has been done on 31st March.
Thank you. Would you, Mr. Goswami?
Yeah. So I think one of the questions has been answered already by Akhilesh sir about the uniform application of notification 54 of 2026. So I think now we are very clear as to in what circumstances we will invoke GAR, in what circumstances we will not invoke GAR. The other anti-abuse rule is the principal purpose test. I think we have a circular which deals with that it will always be prospective. So I think as regards these anti-abuse rules that is in the treaty and in our domestic law, I think there is clarity. I do not, at least in my discussions with the field offices and all, I don't think that there is any confusion in their mind. So I don't foresee any difficulty. The only other thing is the judicial anti-abuse rule. That is something that the executive cannot really place any fetters on. So I think we don't foresee any problems over there. The second question was that whether JAR and GAR can operate simultaneously. Indeed, they can, because I think it was in Suranjali's presentation that in most of the countries, except I think China, which was one country which creates a kind of a hierarchy that it chooses SAR over GAR, but it's a principle that is recognized everywhere. The important point is that as and when these anti-abuse rules are deployed, they should be deployed with certain rules. There should be, and there should be a framework which we have tried to create, and its efficacy will be tested. And if it is found wanting, we are always willing to make any changes in that. The final point was about the Mauritian law. But the point I was trying to make was that the issue of substance is recognized everywhere. Now, a TRC is issued under, it's an operation of a domestic law of another country. The other country is giving us the TRC. Now, what they choose to do or what they do not choose to do is something that we cannot dictate. I mean, we've had this question coming up to us many times, that will India lay down any principles which for a TRC to be issued by another country. It is something very awkward for us to do when we receive TRCs from 10 other countries, to tell them that you should follow all these principles. So that was the limited point of what I was trying to say. So fine, that's my response.
Thank you so much. I think that's a wrap for our panel, and I'd like to thank all the panelists for joining us, and Justice Easwar, who couldn't make it in person but joined us online very kindly. So thank you.